Is it a constitutional violation for the prosecution to listen to the phone calls of an incarcerated pro se defendant as he preps his witnesses? To find out, you have to read People versus Dixon, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Dixon. The citation from the New York Court of Appeals on this case is 2024, New York Slip Opinion 05176, published by the New York Court of Appeals on October 24th of 2024. The issue in this case is whether an incarcerated individual or incarcerated defendant, we call them pro se defendant who's representing themselves, is that defendant's constitutional rights deprived by the prosecution listening into his jail phone calls where he's preparing his witnesses for trial. To understand and appreciate the context of this case, you have to know a couple things. First, that defendants in New York and all over the country, but in particular New York, have a variety of constitutional protections, rights, to help ensure that they have due process and the protection of the law. Amongst those rights are the right to have a meaningful opportunity to present a complete defense, the right to offer witnesses, testimony of witnesses, the right to compulsory process, to subpoenaing witnesses, the right to self-representation, to be their own lawyers if they choose to be, the right to prepare and present a defense, the right to actually prepare your witnesses for trial. And the other thing you have to know is that when defendants are in jail waiting for trial, they can use phone calls. They can use phones. There are phones that prisoners can use, but there's a big sign next to all the phones in the jails that say, "Be aware, your call may be recorded and monitored." And that's true. If a prisoner makes a phone call, an inmate makes a phone call, they put their inmate number first and then they make their phone call. And those phone calls are preserved and prosecution can get those phone calls in certain cases. Now, what's the facts of this case? The facts are the defendant was accused of repeatedly sexually assaulting multiple people, multiple children, 2 that were under 11, 1 that was under 17. And it was claimed that he was recording some of these sexual assaults. So the police got a search warrant for his home and his computers. The defendant was charged with several counts of coercive sexual conduct against a child. And originally, bail was placed on him, but he made the bail. He posted bail. So he for 2 years before the trial, he was out on bail, preparing for the trial. And then in the middle of the trial, he found out who the next witness was going to be. And lo and behold, right before the witness was going to testify, something was released on the internet negative about that witness. And so the judge said, your bail's revoked, you're going in. And so in the middle of the trial, the defendant was placed in jail. His bail was revoked, and he had to now proceed the rest of the trial from jail. And in the course of this trial, he was pro se, meaning he had fired his lawyers. The court had given him a legal advisor and had given him an investigator to help him, but he was pro se. He was his own lawyer. During the course of that trial, after he was put in jail, he made some phone calls preparing witnesses from the jail phone. And the prosecution got a hold of those recordings where he was preparing his witnesses. And during the course of the trial, it became clear when the prosecution started cross-examining those witnesses about things that they had said on the phone calls to the defendant in jail. And so when the defendant was convicted and sentenced to jail, he appealed. And his basis of his appeal was, that was not fair. You had an unfair advantage because you were listening to my preparation of my own witnesses. I have a right to prepare my witnesses and present a complete defense, and you impeded on that by listening to my phone calls. The appellate division affirmed the judgment of conviction, did not reverse it, and it goes to the Court of Appeals. And here, they go through all those rights we talked about that a defendant has. They reaffirm that a defendant has those rights. They say the opportunity for a lawyer to communicate confidentially with potential witnesses is essential to the preparation of a defense. And that's no less true for a lawyer that's not a defendant as it is for a pro se defendant who is his own lawyer. So it sounds like they're going down the in the decision about saying, well, yes, he has a fundamental right to present a defense and prepare witnesses. And they say pro se defendants who use jail telephones to prepare witnesses to discuss trial strategies may not fully appreciate that their conversations may be divulged to the prosecution. But then they say, here there was no violation of his rights. Why? Because he was out on bail for a long time, for nearly 2 years, where he could have been preparing his witnesses, and he had other means to prepare his witnesses. He could have prepared with them in person in jail, or he could have asked the judge to let him prepare the witnesses in the courtroom. And he had the investigator and the court-appointed lawyer advisor. So basically they say on the unique facts and circumstances in this case, there was no violation, but they say everything he's saying about having a fundamental right to prepare my witnesses and to have privacy when I do that, that's true. But they say in this particular fact, under these factual scenarios and circumstances, there was no violation. And that's the case of People versus Dixon. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.